Hello, this is David Mandell. I'm one of the principals and founders of OJM Group, and I welcome you to today's webinar. This is a series. We do webinars at OJM Group every month, and we have a number of experts and top people in our firm, and they present webinars like I'm going to do today in their area of expertise. Today's talk is on asset protection, and that is my area of focus. And this is something that I think is a field that I've been in since the mid-90s, and it's one that I think a lot of people have not gotten good information on. So I'm hopeful that today's WebEx will be valuable for you, and certainly this is the beginning of an educational process. At OJM Group, we certainly have a lot of free content, not just WebEx materials, but books and articles and special reports, and a lot of information that you can get to educate yourself on this and other topics, and ideally even speak with us. And we're always happy to have an initial consult and speak with the people who might become clients, and we do that always without charging anything. So our goal is to answer questions and speak with people and see if there's a fit between our firm and what they're looking for. So before we get started, as someone who practiced law for 12 years exclusively before I came to the consulting side, obviously disclaimers are important, and really we're a couple of important points here. One is you can't really just take this and try it at home. There's going to be some tax topics, there's going to be legal topics here, but this is not legal advice or tax advice. Certainly this is important to speak with an advisor about your specific situation, especially on asset protection planning. The planning is very state specific. There are some general multi-state concepts that we're certainly going to go into, and certainly tax implications on a federal level are the same in every state. But you know, the beauty is in the details, as they say, and that's very true in this area of planning. And your plan might be very different to shield assets and put some protection around personal and corporate planning. It might be very different than a colleague who's in another state, or even a colleague in the same state but in a different situation. So it really is very specific, not cookie cutter. What I'm trying to do today is just lay out the basic concepts and hopefully get you thinking in terms of how some of these things could play out in your situation. So as I mentioned, we're pretty prolific here at OJM Group. I don't think there's a firm out there that writes as much as we do. We've, depending how you look at it, we've done over a dozen books over the years. We seem to come out with one or two every year. If you're a physician, we have certainly books that are specific for doctors. If you're not a physician, a business owner, entrepreneur, corporate executive, investor, etc., then we have plenty of books for you as well. Wealth Secrets of the Affluent, the one on the bottom left here, Fortune Building for Business Owners and Entrepreneurs, one of our most recent books. And we're always coming out with new materials. So keep on the lookout and come back to our website at ojmgroup.com often to see what we are coming out with. And always we're happy to get those books out to you for free in a hard copy form. We have a lot of them in the Kindle and iPad form that's easily downloadable and doesn't take up any paper. So feel free to contact us to get some free materials. So today's presentation, I'm going to spend time on corporate planning, which is how to protect the key key corporate assets from lawsuits. We talk about cash flow protection, which again really applies to a business or professional practice, and the key here is really a lot of the things that protect cash flow can also be very significant tax reduction tools, so that's always of interest. And personal planning, we're going to talk about how to protect personal assets from the home to investments like stocks and bonds to rental properties and everything in between. So, you know, why why asset protection? Why protect assets? And I think for some people, there may be some, physicians and certainly specialty physicians like surgeons and OBGYNs on the phone, or there may be people watching this who are, like some of our clients, product manufacturers, who are real estate owners, who are real estate developers or rental property owners, et cetera. And for all those kinds of folks, liability is right there. The second bullet here, malpractice, product liability, landlord liability. People think about these things all the time because there are claims fairly often in those areas. Now, insurance is always important, and we're not going to talk a lot about it today, but certainly in our books, and when I'm doing an analysis for a client, we're going to review clients' property and casualty insurance. That might be malpractice for a physician. That might be a homeowner's. That might be umbrella policy, etc. So those are all important. But there are coverage limits. There are exclusions. There are risks that you can't really get insurance for. For any person that is an employer who owns their own business, there's employee claims, which are actually oftentimes more numerous and can be more difficult than malpractice or product liability, professional liability claims, because they're often not covered by insurance. So wrongful termination, harassment, violation of fiduciary duty, all sorts of theories of claims, and there's plenty of attorneys out there who are willing to take those cases and press them on a contingency fee basis, where the client doesn't, the plaintiff doesn't have to pay anything. So it's really kind of a no-lose situation for them to bring an action. So whether it's premises liability from real estate, or malpractice, or product liability, or employee liability, or personal liability from car accidents, or things that kids might do that are imputed to you, I think that asset protection is important. Now, in our firm at OJM Group, it's generally not the most important thing we're working on with clients, because the odds of losing an asset to a lawsuit are low. Okay? Yet the odds of paying taxes are 100%. Yet the odds of needing assets for retirement are extremely high. Yet the odds of losing assets to a market downturn or poor investments is fairly significant. So asset protection, I think, is one part of an overall wealth plan, but it shouldn't lead, and it shouldn't be overly expensive. So how much should you spend to protect assets? Should it be 1% of the value of the asset? Should it be 1/10%? Should it be 5%? It's really up to a client to determine. I think there's some value. If you have a net worth of $1 million, you should spend some dollars to protect that. If you have a net worth of $10 million, you should spend some to protect that. But it shouldn't be overly onerous. And ideally, especially off the business side, we can show you ways to reduce taxes that more than pay for the cost of the protection. Then you're really getting a win-win. You're actually getting paid by the government to protect your assets, which is always a good thing. So we can't go too far into the discussion of asset protection without talking about the sliding scale that I've developed over the years. I think really probably in the third or fourth book we did in the early 2000s, about 10, 12 years ago, started using the sliding scale, -5 to +5. And I like this because it gives clients a way to compare different levels of exposure and different levels of protection, because not every protection tool is the same. Very important. And the question that I sometimes get from potential clients is, am I protected or not? Does this protect me or not? That's not really the right question, because it's very rare that an asset is completely protected. There are some tools, we'll talk about it, and in some states it's not rare at all. But for most clients, they're not going to be able to get to the highest level, what I call +5, across the board. You have to look at every asset, asset by asset, at both the business and personally. You got to assign a level of exposure the way it is today, and ideally it's trying to move that, especially the significant assets, from a negative position to a more positive position. And if we can get a client's most of their net worth, again, not expensively, and ideally with some tax benefits, into the plus side, then I think they can sleep at night knowing that they're not totally exposed, that they're not laying out there in the wind, that if the worst happens, that they have claims against them and judgments against them, that they're going to have a very good position to either dismiss the creditor or negotiate a favorable settlement. So anybody who's practicing in this area, any attorney, let's say, in the asset protection area probably would agree on the -5 to the +5, meaning the extremes. -5 are assets that have total exposure. That could be assets owned in your name. That could be assets in a partnership. That could be assets in a business, like a corporation, subject to those business creditors. No protection there. At the +5 are assets that are totally protected, and those are assets that are either completely given away with no strings attached, of course, but that's an extreme move to protect assets, to give them away, or more likely to use federal and state exemptions. And every state and the federal government gives us assets that under the bankruptcy code and under the lawsuits are exempt. They're not exposed. They're truly the assets that are quote-unquote judgment-proof, lawsuit-proof, are those. But they vary significantly between the states, and you'd be surprised at how many people say they're interested in asset protection, yet they're not maximizing what they're using on what they have to use under their exemptions. So they're muddling in the middle, and they're not using the actual assets that are protected, the asset classes. So we're trying to get clients to use those, and they can. Some states are very limited, so we can't get clients up to the +5 in any of their, or very small part of their net worth. In between the negative and the +5 are tools that I used to put in place all the time when I was practicing law, and that OJM Group we're often advising and working. I'm working with the client's attorney to get in place tools like limited liability companies, limited partnerships, some tenancy by the entirety ownership form, certain types of trusts. All of these kinds of structures are well protected, but they're not totally protected. So they put you in a position that you could negotiate something with the creditor if you got a judgment against you, but they're not +5. They're not off the table. You will negotiate. You will need to pay off somebody who's in that position. So, but that's usually going to be the best, or often going to be the best position you can be at, to be in a position to negotiate for many of your assets. We're going to try to get you +5 as much as we can, but for a lot of the assets, you're going to be in the middle. And lawyers can disagree on whether it's +1, +3. A lot of lawyers don't even use a scale, but they do recognize that these are ownership forms, or these are structures that provide some protection, and some solid protection, but they're not totally exempt. They're not off the table. You will have to negotiate a settlement, and you will have to pay something out. So, but you're not totally exposed like you are in the negative position. So our goal, again, is to move clients from a negative position, the asset by assets and negative, to the positive, and try to get them to take as much +5 as possible. Now, if you look at the +5 position, if you look at the assets that are truly off the table, those are ones that typically have significant non-asset protection benefits. Okay? So you might think as a limited partnership or an LLC as an asset protection tool, or an offshore trust as an asset protection tool, or an asset protection trust as an asset protection tool. And those are all those tools. Now, they may have other benefits from estate planning, but typically those don't protect as well as the best protections, which are the +5. And the +5 protections are exempt assets, and exempt assets are things that you don't think of as being asset protection, like your home. Okay? In some states, like where I live in Florida, homestead protection is unlimited. That's a +5 asset. Okay? And in a lot of states, you have a significant homestead that's +5 exempt asset off the table. Is it an asset protection tool to have a home? Well, I don't know. In some states, it can be. Qualified plans like 401ks or profit sharing plans or defined benefit plans, and even IRAs in most states are exempt under federal law, bankruptcy law. They're very well protected. So again, are these retirement tools? Are these tax reduction tools? Are these benefit plans? Are these asset protection tools? Well, the answer is yes, they're all of those. So the protections here are significant, and they are asset protection tools, but they're not. And that's really the point of the slide, is that asset protection must be implemented in a multidisciplinary approach. There's some attorneys out there who speak to a lot of other lawyers in the field, the ABA, et cetera, and they're very adamant that if you do asset protection in it by itself, it's very risky, because depending on when a claim comes, they could have a very good argument that that protection could be undone. There's a whole set of laws called fraudulent transfer. And fraudulent transfer means the ability of a creditor later, after the fact, to undo planning because it was done specifically to hinder creditors. Now, the longer or the sooner you get this planning in place and the longer time goes on, the less of an argument people have, because it's a timing argument. Did you put this in place to hinder my ability to come after you? And so any of you listening who may have a claim, and you may not even know, it's especially important if you think there may be something lurking now to have planning in place that has non-asset protection reasons for it. Very, very important, because it's much more likely that something that's specifically and only for asset protection will be undone in the future, where a tool like owning your home or putting money in a 401k that has a lot of other benefits to it in addition to asset protection as a side benefit is not going to be undone, because there's a lot more economic substance to it than there is for a tool that purely has asset protection benefits. So it's very important to have asset protection be put in place alongside tax, corporate structure, investments, estate planning, gift planning. All of these tools relate to asset protection, and they should be done together, not separately. So let's talk about corporate planning now. Okay. Now, the first slide is your multiple entities, but I want to back up for a second and talk a little bit about corporations, because most people have their businesses in corporations, and corporations, okay, are -5 in some ways, and properly done +5 in some ways. So we have to talk about inside creditors versus outside creditors for a second. Inside creditors are creditors in lawsuits that are caused because of the business itself. So let's use a business where there's product liability, they create products, okay? And or they have employees. So let's just use the idea of employee going to get lunch for the office and getting into a car accident. Now, whether you have a corporation or an LLC or some kind of legal entity, if you're the owner, but you weren't involved in that, you weren't in the car, you weren't driving, you weren't supervising them, they were driving in furtherance of the business, they got into a car accident. The person's going to sue them. They're going to find out, oh, they were getting lunch for the office. They can sue the business now, okay? That business is a corporation, LLC, some kind of legal entity. Then that entity is going to be viable. So in that case, the corporation is -5. All of its assets are subject to the claims of that car accident lawsuit. So if there's accounts receivable, if there's real estate, if there's intellectual property, if there's cash flow, if there's cash, all of that could be taken if that lawsuit is successful. If they get a judgment against that business, they can come after the business assets. That's why we're going to talk about protecting the business assets in a minute. Okay? But they shouldn't have a claim against you as the owner and maybe the head CEO of that business, okay? Because you weren't supervising, you weren't involved in it. So in that way, a corporation is -5 because its assets are liable, but it's +5 in that it protects you. Just like if I sued Facebook today for some kind of privacy violation, even if I got a judgment against Facebook, I would not have a good claim against Mark Zuckerberg's individual assets, okay? Unless I could show somehow he was personally responsible for it. That's what the corporation does. Or if I own stock in Facebook as an owner, my personal assets aren't liable. I could lose the value of my stock, but they can't come after me personally, okay? And so that's valuable, but also if I sue Facebook or I sue your corporation, I get a judgment against Facebook, I get a judgment against your corporation, I can come after Facebook's cash, I can come after your assets, the business's assets. So having a corporation or an LLC, et cetera, is important to protect you personally. You never want to have a business without an entity, but it doesn't protect the entity from its own claims. Also, there's a difference between a corporation and an LLC. Let's say there's a lawsuit against me, totally unrelated to my business, say a car accident, and they get a judgment against me. If I have a corporation has no protection for the stock. So whether I own stock in my corporation or stock in Facebook, if they get a judgment against me, they can take my stock. In Facebook, they can take my stock in my business. Now, if my business is protected by a license, that's a different story. Now, if I have a corporation like I have my old law corporation, that is protected by the California bar rules. It's a California law corporation, so you can't own it unless you're a member of the California bar. Okay, so there's corporate protection there. But if it's like a manufacturing firm or an ice cream company, they get a judgment against me, they could take my stock and own my business. So I generally don't like corporations if there's not a licensure protection. LLCs are much better because LLCs have protections that corporations do not. We'll talk about that in a little while. So that's important to understand going into this. Now, if you have multiple locations, if you have multiple business units, or even if you have just one business unit in one location, you may want to separate different functions in multiple entities and separate different employees and separate different assets, because a claim against that business, as I talked about, is -5. So if there's a claim against my corporation, my LLC, because of something it did, they can come after all the assets of that. But if I separate it, let's say I have 2 restaurants, and I have one restaurant in Corporation A and one restaurant in Corporation B, one restaurant in LLC A and one in LLC B, there's a claim against LLC A. They can't come after the assets, the cash flow, the receivables, the real estate in LLC B. Okay? And you might be able to do that even with one company by setting up a management entity and taking some income there and putting some employees there. So if you have a medical practice, maybe you have all the reimbursed medically related employees in one place, and you have the front office and you as the CEO and the billing people and the management company. You have if you have a manufacturing company like we've got, you might have, again, a bunch of people in manufacturing of one entity, one product there, and another product there, and another product there. And so you have multiple entities. This allows you to protect the different cash flows and entities from a claim against the business, because they have to choose which entity they're going to sue and which one they have a claim against. Okay? And if one's unrelated, it shouldn't have any liability. And then you also have tax benefits. Remember, I talked about tax benefits. There are different types of ways a business can be taxed, and today's not a tax webinar. We have others that my partner, Carol Fu, who's CPA with 25 years of tax experience, does. And that there are benefits to S corporations. There are benefits to C corporations. There are benefits to entities, taxes, partnerships. And if you already have an S corporation, it might make sense to add a C corporation and take advantage of some of the things you can do there. If you already have a C corporation, it may make sense to set up a partnership. If you already have a partnership, it may make sense to set up an S corporation. Having multiple entities is just like that old saying, don't put all your eggs in one basket. It's true from an asset protection point of view. It's true from a tax point of view. Okay? Now, even if you have multiple entities, or if you don't, certainly if you have valuable assets inside of a business, you want to protect those assets, because, again, vis-a-vis claims against that business, there's no protection against those assets. If I get a claim, a judgment against a business, I can go after its equipment. I can go after the real estate. I can go after its intellectual property. So there's a good article, a good chapter by my old mentor who passed away a number of years ago, Arnie Goldstein, and in that chapter of his book, he said, never own the most valuable assets of the business in its business. Makes sense. Okay? Don't put all your eggs in one basket. If it's valuable equipment, keep it outside in an LLC with the right protection provisions and lease it back. If it's real estate, get it out of the business, have it in an LLC, lease it back. If it's intellectual property, get it out of the business, license it back. So if there's ever a claim against that business, what do they have? They don't have the real estate. They don't have the equipment. They don't have the intellectual property. All they have is a lease, and they can't come after the underlying assets. Okay? And you might even put in that lease a termination clause, a duress clause. So if there is a claim, a judgment against them, and they try to come after it, you can terminate that. Set up another operating entity and keep the real estate, the intellectual property, the equipment completely separate. Okay? Don't put all your eggs in one basket. Very simple. In concept, more complicated in practice. Again, LLC versus corporation, assets inside should be moved out. Now, cash flow for a business is often the most valuable asset in the business because it turns into your income, okay, as the owner. And the benefit of protecting cash flow, it's also sometimes the most attractive to a creditor, because why do they want to go after equipment which they have to go sell? They'd rather get to the cash and the cash flow that's coming in. Also, this is where you can save taxes. So the other things I was talking about, moving assets into different entities and leasing it back, having multiple entities, sometimes that's going to save you taxes, okay, and there are some ways to do it. But your most significant tax planning is probably going to be on protecting your cash flow. Okay, so how can you do that? You can look at qualified retirement plans, which most businesses have, but they haven't been reviewed in a while. Fringe benefit plans, or what I call hybrid plans that have elements of both. Non-qualified plans sometimes are helpful as well, although often those are not well protected against claims against the business creditors. So we start with qualified retirement plans, okay? And most of you listening probably have one in your business. Qualified retirement plans or pensions, profit sharing plans, etc. These have asset protection under federal law. Under federal bankruptcy law, ERISA qualified plans are exempt in bankruptcy. So we always know we can use that Chapter 7 bankruptcy to protect it. And most state laws have also protected qualified retirement plans at an unlimited amount, if they're so qualified, under state law against lawsuits. So you really have terrific protection. However, you have to look at the tool in entirety. And there are some negatives to it. As a business owner, you have to cover all your eligible employees, okay? And there's full income taxation on withdrawal. So people love a qualified plan, pension, profit sharing plan, defined benefit plan, even for these purposes, a SEP IRA. Well, IRAs are not as well protected under state law in some states, like California and others. They are exempt, not unlimited, but in various ways under bankruptcy. And if you want to learn more, certainly give us a call. Happy to talk to you about it. So IRAs are sort of similar to this. But like a SEP IRA, again, get a deduction today, you're going to pay tax on the way out. Qualified plan, you're going to get a deduction on the way in, tax on the way out. So while it may be a very good tool for asset protection, when you look at the slide here, which shows the top marginal federal rate only for since the income tax came in every 10 years since 1920, and the income tax is about 100 years old now. So we have about 100 years of data. What you'll see is that for most of the 20th century, the highest marginal rates were above 60%, and that didn't even include state income taxes. Okay, now they've come down, and right now we're at the third lowest point in the federal tax in terms of the highest marginal rate. So again, if you're getting a deduction today for your qualified plan, is it a good deal? Well, who knows? You have to know what taxes are going to be in the future, right? And they may be higher. So it may be that you're paying taxes, you're getting a deduction today at a lower rate and paying tax on the higher rate. When you look at that and you combine the cost of employees, it could be a very bad deal for clients. Okay. Now, a lot of clients say, well, and a lot of the information out on the web and in the financial literature says, well, most people are going to be a lower tax bracket in retirement because they're having less income. And that's true for many people, but it's not true for a lot of our clients. A lot of our clients, they're actually building a plan where they're going to have about the same income in retirement. They may not be at the highest marginal rate, but they're going to be pretty close to it. Okay? So if they're at the 33% or 35% or 39.6% tax rate in retirement, plus state rates, plus right now the Medicare tax on the income, and rates stay the same or go up, the qualified plan might have been a bad bet. Now, we don't think it makes sense to get rid of qualified plans. In fact, we have one at our own firm. But I don't put a lot into it anymore because I have a pretty big balance in qualified plans. I've been funding other types of plans more to hedge against this. And that's really the theme when you listen to us on the tax side of our firm, tax diversification. Qualified plans are one bucket. They're a bucket that you get a deduction for today that grows tax-free that's going to come out ordinary income tax. You have to hedge that bucket with buckets that are going to come out not as ordinary income in the future. Capital gains, or better, no income tax. That's why some clients use Roth IRAs, where you pay your tax today and pull it out tax-free. Okay? Now, the asset protection is great here. So from an asset protection point of view, it makes sense. That's why when we're talking with clients, we are balancing the asset protection versus today's tax benefits versus the future tax planning. Okay? It has to be done in a multidisciplinary way. So if you're going to use a qualified plan, you might as well use the best formulas you can, and those have changed. And if you haven't looked at your qualified plan in some years, it's time to look at it. Okay? IRAs, as I mentioned, okay, have federal bankruptcy protection at the +5 level, not unlimited. It depends. Some are unlimited. It depends what type of IRA you've got, whether it's a rollover, a SEP, or traditional, et cetera. The IRA protection on a state level is very different among the states. Again, California is, as an example, not a good one. And for some clients, we're telling them to roll their IRA into a qualified plan because the protections in their state for qualified plans are better than IRAs. They've got a rollover IRA from an old job or old business, and they're able to better protect it simply by rolling it in to the qualified plan. Sometimes that makes sense. Okay. Now there's a whole host of plans out there that aren't qualified plans that still may provide you asset protection and some tax benefits. Fringe benefit plans are one whole section of the code. In fact, there's a whole publication from the IRS 15B every year that comes out that talks about fringe benefit plans, and there's one under that brochure, under that tax regime, under the tax code. It's been in place for decades, and it can be done in addition to a qualified plan, and allows you to build up cash values, to build up value for retirement in that fringe benefit plan. And typically, it can be extremely beneficial from an economic point of view, and it works differently than your qualified plan. In fact, you pay tax up front, but depending on how this plan is structured, you may pay tax on only about 60%. It then grows tax-free and comes out tax-free. So it's a terrific hedge, kind of like a Roth IRA, but in some ways much better, against your qualified plan. So I have this plan in place, and it's a good plan that hedges against my qualified plan. So this is a place in the future I can get assets, get value that I want to come out tax-free. My qualified plan is a good place for me to take money out where I'm going to get money taxable in the future. But today we're talking about asset protection, and in about 20 states, this plan is exempt, completely +5 at an unlimited level under state law. And in the other 30 states, it can be structured for a +2 level of protection. It can grow inside of an LLC. So this, I call it a hybrid type of plan because it has elements of a qualified plan and elements of a non-qualified plan. However, it can only be used for owners if you have a C corporation. So again, not a tax discussion today, but for many of you, you don't have a C corporation running your business. You have an S corporation or a partnership or something else, a disregarded entity. And so this gets back into why asset protection has to be tied into tax planning, which has to be tied into, if you have a business, corporate planning. So we'll spend 1 second on this plan. As an actual example, this plan for a 53-year-old client of ours in California who's an attorney, if they put $100,000 into this plan for 5 years versus not doing, this is what we show the client. What is it like if they just pay their taxes, okay, which is this is their taxes, they're at about a 56% rate, marginal rate, and they give it to their broker or give it to a firm like ours that manages money, and we invest it, and there's some taxes along the way. And then in the future when they retire, they're going to turn it into cash, okay, sell it, pay capital gains, and turn it into income for 65 to 85, okay? And we assumed a 6.5% rate of return. So that was not doing, just paying your taxes, keeping the dollars flowing, paying your taxes, giving it to a broker, reinvesting it, and then pulling it out in retirement. On the other side, we show the exact same rates of return, so no difference there, but doing this plan versus not doing it, okay? Putting the money in this fringe benefit plan and getting some tax relief up front, but really getting the value of tax-free growth and tax-free access along with the asset protection in many states, okay? Well, for this plan and this client, who's in a high tax state but is also in their 50s, the numbers look even better if the client's in their 30s or 40s, we have a significant difference here, okay? You can see that if they just did it on their own, they just kept doing what they're doing, they pay tax, okay? $100,000 would probably turn into about $45,000, and then they'd be able to grow it over time and pay some taxes, and then turn it into tax-free or after-tax retirement income, okay? That would turn into about $420,000 of income over time, okay? And however, on the fringe benefit plan side, they would pull out over $1 million of after-tax income, which is an improvement of about $600,000 of after-tax income, okay? And that's quite significant. That's almost $1 million of pre-tax income. That's like having $1 million more in your qualified plan with the same rates of return, and this is funding it only for 5 years. Okay? So you can have a significant benefit, financial benefit, using this fringe benefit plan for some clients. For some, maybe it doesn't make sense. Okay? So the point is that if you have a qualified plan, which is asset protected under federal law, and if it's ERISA qualified, it may be well protected, probably is under state law. IRAs, okay, we have to examine your state rules to see how they're protected. But if you're going to do a qualified plan, you want to maximize it. If you want to hedge against your qualified plan, if you believe tax rates are going to increase in the future, if you think you'll be at a higher income tax rate than, let's say, medium, middle of the road, let's say if you're one of the higher brackets, if you think you're going to be in those one of the higher brackets, have income of, say, $150,000 or more per year in retirement, then you really want to hedge against the qualified plan, and the fringe benefit plan could be a way to do it. So if you haven't reviewed in your business or practice different benefit plans, then you should. Another tool which has tremendous risk management, asset protection, and tax benefits are a small captive insurance company. This is creating your own small insurance company under a particular code section that's been in place. It hasn't changed since 1986, which is almost 30 years. And even before that, it was in some other code sections. Congress has always encouraged small insurance companies. This is creating your own company. Now, notice here on this chart, owners are the same. So again, you own your own insurance company, and then that insurance company writes insurances on your operating business or practice. But because that small insurance company is taxed under a particular code section, it does not pay tax on $1.2 million of annual income. So you can have your own insurance company that is tax exempt on $1.2 million of annual income under this code section. So this captive can be a tremendous asset protector because it's providing you risk management and potentially insurances for things you don't have. Also, the captive itself can be structured to be a +5 protection by having it owned by an irrevocable trust for your heirs. Okay? Not only that, you're turning taxable income, okay, that if you didn't do the captive would be taxable to you, into tax-free income to the captive, because the captive under this code section does not pay tax on that income. Now, I could do a whole hour on small captives, but the point here is that this is a tool that exists, that's in the tax code. There are thousands of them in operation. You've got to do it right, okay? And we don't set them up here at OJM Group. We manage a lot of the reserves and investments inside of captives. You've got to find the right attorneys, the right captive managers, the right actuaries, the right accounting firms that can do the audits and the tax returns. It's some of the best providers have a turnkey program. And the captive can be a tremendous tax planning tool, but it really starts with risk management, insurance, and asset protection. So that is part of what you're looking for. Then a captive can be a tremendous tool, not only as an asset protection tool, but as a tax and wealth accumulation tool as well. So far what I've talked about is at the business. Now let's spend some time talking about planning for the personal assets, okay? And let's look at that. So first you got to talk about how do you title your assets, right? Is it in my name? Is it a spouse's name? Is it in a joint name, etc.? Now, if it's in your own name and it's not an exempt asset, it's -5. There's no protection whatsoever. We have to protect those assets, okay? Some clients will say, well, I just put everything in my spouse's name. And generally that does not work, especially if you're the one earning the income, having the liability, because if the asset can be traced back to you then, and you're using it, let's say the home, you're living in it, the investment portfolio, you're the one contributing to it, then just by putting it in the spouse's name, that may not be effective. And in most states, it's not. There's something called substance over form, and the substance would be that's a joint asset and treated jointly. You're just putting it in the spouse's name. Now, there's tenancy in common, TIC, and joint ownership, which, again, are joint ownership forms, and a lot of couples, married couples or business partners have assets in tenancy by the in common or joint ownership. And generally, those ownership forms are in a -3, meaning they're completely vulnerable to a claim against both of you, and they're half vulnerable to a claim against one of you. So if you're married and you have a claim against you, probably half that asset is liable to the claim, okay? And that might be true, again, in most states for spousal ownership. So just because it's not in your name title-wise doesn't mean it couldn't be exposed to your claims, depending how it's being treated and used. Tenancy by the entirety, however, is a joint ownership form in about 10 or 12 states that, depending if it's real estate or personal property, has a tremendous level of protection against a claim against one of the spouses. So here in Florida, we have tenancy by the entirety, and a married couple in Florida, if it's owned in that ownership form, a claim against one of the spouses is ineffective. So if LeBron James is married and he has property in a and he's a Florida resident, and he has property in tenancy by the entirety, then a claim against LeBron James would be ineffective against tenancy by the entirety property. They could not come after it. It's totally protected. Now, we don't consider it +5 because if there's a claim against both he and his spouse, there'd be no protection whatsoever. It's -5. They can come after all of it. And if he gets divorced or dies, etc., then that ownership protection is eliminated. So it's a great place in the states where you can use it to protect against one of the spouses. However, we like to combine it with other tools like LLCs and limited partnerships because we're still concerned about claims against both spouses, and tenancy by the entirety doesn't protect against that at all. Community property, about 10, 15 states are community property, a lot of the western states. In community property, any community debt generally, the general rule is can come after, or I should say, any community property is vulnerable to any community debt. And any community debt is typically any debt incurred by either spouse, any liability incurred by either spouse during the marriage. So in community property states, it could be that all property that's considered community property is subject to claims against any of the spouses, either of the spouses. So in that case, everything is sort of -5 against everybody in the worst position. So in community property states, again, general rule, your state may be specifically different, you really do need to go after and protect those assets in a significant way. Okay. Now, we always said, if you go back to the sliding scale, I like to start with exempt assets because exempt assets are truly protected. Okay, those are exempt. Those are off the table. As long as there's no fraudulent transfer and everything's been done in the right timing, an exempt asset is just as it sounds, exempt, outside of bankruptcy, outside of a lawsuit claim. Federally, as I talked about, qualified plans and IRAs with some limitations are protected if they're properly qualified. Take what the state gives you, and I talked about this before. So many clients are not maximizing what they have under their state law. Why do I like it? Not only is it the best level of protection, but also there's no gifting. There's no compliance rules in terms of keeping things in compliance as a legal document. There's no counting fees. There's no special taxes or state fees. All of those things are involved when you start talking about limited liability companies, limited partnerships, and trusts. There are gifting issues. There are compliance issues. There are accounting fees. There are special taxes. There are tax returns. There are state fees. All of those things, legal fees, etc., that go into the legal tools we'll talk about in a minute, which you don't have with exempt assets. Okay, it's also the best asset protection. It's not asset protection. So you want to take advantage of state exempt assets. Now, what assets are exempt? Before we turn to the next slide, again, some states there's homestead. Some states cash value life insurance. Some states cash value annuities are exempt at a +5 level, unlimited. In Florida, we have a wage account. In some states, qualified plans. In some states, IRAs. So you've got to get a sense of what is exempt in your state and the value and the amount of which it's exempt, and make sure you check off those boxes and get those done. But even in the states that have the best protections, like Florida, okay, you're still going to need other tools generally if you have a net worth that is worth protecting. And because we can't get everything into an exempt asset, even in a state like Florida, and in a lot of states like California, I could name almost any state, you're not even going to get close with the exemptions. So you're going to use LLCs, which means limited liability companies. You're going to use FLPs, which means family limited partnerships. And you're going to need to use these tools. And these tools I consider +2. And why do I consider them +2? Because they're in the middle of the scale. Okay? They provide certainly much better protection than the -5, or than even a joint -3 where it's half vulnerable. Okay? If done right, the creditor cannot just come in and take the asset. But at the end of the day, you're going to have to negotiate because they have some rights, and we'll talk about the next slide what those rights are, which is much different than a +5 exempt asset. So +5 off the table, -5, -3, they can come after it, and nothing you can do about it. +2 puts you in a position to negotiate a settlement, but you're going to have to settle. And that's because if done properly, okay, the LLC or limited partnership provides a charging order protection. So let's say I give a lecture that's so boring that someone, falls asleep and hits their head and their family sues me, okay? and they sue me for wrongful personal injury, and they get a judgment against me. If I own $500,000, let's say, portfolio in my name, that's not exempt. It's in my name. It's -5. If they got a judgment, they could take that account the next day. -5, no protection. If that $500,000 of value was in, let's say, an annuity or a cash value life insurance policy, and I live in Florida, it's exempt, or it's in an IRA or it's in a qualified plan in Florida, it's exempt, then that's +5. They couldn't come after it. They wouldn't even come after it. They know it's exempt. There's no way they can get to it. So in the middle, if I have, but let's say it's a portfolio and I can't get it in one of those other tools, if I own that in a limited partnership or an LLC and that tool is done properly and ideally in the right jurisdiction, okay, and it has the right agreement and its formalities, everything is done properly, then they can't just get inside it. They can't get that $500,000. Okay? They don't have a right to become a partner in that limited partnership or a member in that LLC. They can't just go in and get the cash. They don't get voting rights. They don't get management rights. They can't force any money out of it. All they can get is what's called a charging order, and a charging order says, that they get from a court, once they have a judgment, says that if any money is paid from that limited partnership or LLC to my name, then they can come get it. So it's a right to distributions that come out, but they can't force distributions. They can't get to the money while it's inside there. So if I'm in control and I'm the managing member or the general partner of those entities and there's a charging order against me, what's the chance I'm going to pay out money from that entity to myself? They have a charging order against me. Not going to happen, 0. So I really am in control. I can continue to manage the assets in there. I can buy and sell. I can grow the assets there. But they can still sit there with that charging order for a long time. So it puts them in a position to wait, and it puts me in a position to negotiate a settlement. But I can't think I'm going to get away with nothing because they can sit there for a long time. Okay? So it's not an exempt asset where they get nothing. It's not a -5 or -3 where they can get to all of it or half of it right away. They get nothing until I negotiate with them. So this is why we consider it a +2 level of protection, and our very solid tool in the tool bag that we use quite often with clients. I've been using when I was practicing law, set up hundreds and hundreds and hundreds of these. Now again, making these as strong as they can, you want to make sure that they has the proper agreement. If it doesn't have the right agreement, then everything I said is out the door. You have to comply with the formalities. If you're commingling, if the LLC or limited partnership is paying your personal bills, et cetera, then everything I just said is out the window. It can be pierced. Ideally, there's non-asset protection purposes like estate planning and gifting. The key is using the right attorney, because it's not just about the jurisdiction. It's about the agreement and keeping it in formality and how everything works. Now, if you're using just a portfolio, you can use an LLC or limited partnership in any state. We manage at OJM millions and millions of dollars for clients inside of these entities in states that have the best laws for them, not in their client's own state. Now, if you're going to use, as we'll talk about in a second, an LLC for real estate, it has to be used in those states. Okay? But limited partnerships and LLCs, typically every client has at least one. Maybe one for their investments, maybe one for non-home real estate. Now, we talk about protecting the home. Ideally, homestead protection is the best. So again, if you have a significant homestead protection, you want to use that and maybe not go over it. So we have clients who are saying, okay, Massachusetts, I think, is about a $500,000 homestead exemption. To check that, it's around that value. So we might tell a client in Massachusetts who's concerned about asset protection, build up equity in that home until you get to $500,000, and then don't pay any more mortgage. Just pay the interest, or don't put more down than you need to. So you, as you're paying down the mortgage, you'll get to that $500,000 mark over time. Okay. Again, using the homestead as much as you can. If you have a high homestead, put more money in. If you have a low homestead, put less money down. But again, that's an economic transaction that needs to work with our financial planners, because you also don't want to pay a lot in interest. So it's a balancing between how much you should put down and how much equity you should have between the financial concerns and the asset protection concerns. Typically, putting assets in the spouse's name is not effective. Now, in one state where I wrote a book specifically for that state, the 4 attorneys we wrote, or 5 attorneys we wrote the book with, agreed that in that state, you could put it in the spouse's name and still have access to it and still protect it against your creditors. Okay, so that's specific to that state law. That's why it's important to get that input from local counsel. Using a trust for the homestead is possible, qualified personal residence trust, but there's a lot of tax implications, and you're really giving the asset away. So that's generally not used too often. A lot of times we're looking at a debt shield, which again is just a fancy way of saying don't put too much of your net worth in the home if you're in a state that has a poor homestead exemption. So it's a financial decision to decide how much in your total net worth do you want to build up in your home. Okay. For non-home real estate, like second homes, etc., again, we're often looking at a debt shield as well. Sometimes it's borrowing against the money and putting it in something that's protected. Okay. That, again, is a financial transaction. So if you have $1 million home with no debt on it, should you borrow $200,000, $300,000, $400,000, $500,000 on that home to put some shield around it? Well, what's the interest going to cost? Can you write off that interest? What are you going to do with the money? If you're just going to spend it, well, no, now you've actually done worse than getting sued. You've lost net worth. If you're going to do something that protects that, you're going to have to put it in a portfolio that has some that is designed to be conservative and match the cost of that interest. It may not make sense from a financial point of view. You might say, I'd rather take the risk of having the home exposed from a lawsuit point of view than do a loan transaction. For some clients, they're doing the loan anyway, so it's just a matter of being smart about protecting putting the proceeds in a protected asset. So this is an option. Do we recommend it for a lot of clients? No, but it's something that might make sense for certain clients, depending on their interest and their net worth and their cash flow and their goals. For non-home real estate, like rental properties or second homes, etc., we generally recommend LLCs. They're the ideal tool here. They can provide outside protection against claims against the person personally who wants to come after the equity in the real estate, and they also can provide some inside protection against claims against the LLC itself for, by renters, lead paint, slip and fall, etc. If you're not involved personally, then the LLC could provide a lot of protection for non-active, passive owners. So again, if you have second homes, if you have rental property, LLCs are often a very good tool for those assets. Trusts can be used to protect wealth, and I don't have time. I could do a whole hour on trusts, but the key for trusts to protect wealth, they have to be irrevocable. Revocable trusts, family trusts, living trusts, loving trusts, whatever they're called, if they're revocable, they do not provide protection because it means a creditor could force you to revoke it. So what kind of irrevocable trusts are out there? This is a partial list. Everything from domestic asset protection trusts and offshore trusts to qualified personal residency trust to dynasty trust, irrevocable life insurance trust, spousal access trusts, charitable remainder and charitable lead trusts. Any trust that's irrevocable can be structured for solid asset protection, not just against the grantors, which might be you, the one who's funding it, but also against beneficiaries. So if you're worried not only about you being sued, but about your children getting sued or getting divorced, and you want to keep the asset in the family, irrevocable trust with the proper spendthrift provisions are often very solid tools. So obviously I've run through a lot of stuff in a short amount of time, but I wanted to go through a lot of different ideas here, so depending on who's listening, there might be something that's of value. Some of you may be business owners, and the first half of this was more interesting. Some of them may be employed, and so the personal assets is really where you're wanted to pay attention. But remember, this is just the beginning. So we encourage you to get a book, one of our books, one of our materials. Our firm is pretty unique. We're a fee-based consulting firm. It's how we start. We certainly have a large insurance and benefits division. We have a large investment division. We have 1,000 clients we work with. We have a lot of different areas of disciplines. My area of expertise is asset protection. So you could come to us and just hire us to do an asset protection plan for your business. It could be just to look at asset protection planning and do a write-up personally. It could be comprehensive, looking at asset protection and tax and retirement and estate planning and insurances and college education funding and risk management and insurance review, all of those things. When we're looking at a business and the business is of a significant, of a decent size and people have a decent income, then we can offer our firm commitment, which says if we can't show you a way to save at least 200% of our fee, we'll refund the fee. So if tax planning is interest to you, and some of the things I talked about earlier in this webinar were of interest to you, then we'd love to speak with you about that. So visit our website at ojmgroup.com. We're always willing to have a free consult. So you really have no risk. It's really for both sides. We're sort of interviewing you to see what your situation is and see if we can help you, and you're trying to find out about us to see how we might be able to help you. And if we think there is a way to work together, we typically have a second call, which we don't charge for, where we might determine the scope of our engagement, what our fee might be, whether that firm commitment of 200% of our fee makes sense, and then we decide to move forward. So we always have at least one, typically two conversations where we don't charge anything to see, is there any place we can provide value? And with over 1,000 clients across the country, we think there typically is. We encourage you to give us a call. I'm certainly happy to speak with you. Visit our website, and of course, get some of our free books and look for our next WebEx. Thank you again, and have a great day.